Thank you, Angelo, and it's a pleasure to be here this morning. And Larry Folletta and I are going to work through what we think is going to be a valuable component of this presentation today, and that's the concept of sentence advocacy. And we're going to look at it from a couple of different perspectives. Certainly, my perspective is one of a prosecutor. I spent 2 terms as the district attorney of Lawrence County. I just completed a 6-year term on the Pennsylvania Board of Probation and Parole. And in the work that I've done, coupled with the work that Larry Folletta has done as a federal DEA agent, it gives us a perspective of the sentencing process that I think is unique. Certainly, I've had the responsibility of putting people into prison, and I've had the responsibility for letting people out of prison. So I've seen this process from a couple of different important perspectives, and certainly the work that Angelo is doing with regard to substance abuse is extremely important. You know, I would suggest to you, and some of you work in the field, that literally 80% of the people that I saw as a prosecutor and I saw as a parole board member had some substance abuse. Many of those people, unfortunately, also had dual diagnosed problems of mental health issues and substance abuse. So the work that Angelo is doing is very important, and I'm happy to be here to participate in this conference today. What I'm going to do really is talk to you about, and I'm not sure how those are going to click in for me, but talk to you about first kind of the evolution of the right to counsel and effective representation. And really to do that, I'm going to go back about 80 years, and actually there's written materials right there that if we could pass those out and you can follow along. And we're going to try to move along as quickly as we can. I know that there are other presenters and that you have other things that you want to do as well today. But going back 80 years, you know, in this country, someone charged with a crime wasn't even afforded the right to counsel. And it wasn't until a case known as Powell versus Alabama, in which was kind of the prototypical Southern racist prosecution. Powell was one of what was known as the Scottsboro Boys, 9 African-American men who were charged with raping 2 white females. They went to trial without an attorney, an all-white jury. It was a rush trial. It was actually, there was attempted lynching. There was a mob crowd that these young men had faced. And they also faced the death penalty because rape at that time was a capital offense in Alabama. Their case ultimately made it to the Supreme Court, and the Supreme Court at that point said that the United States Constitution, due process required in capital cases that an individual, if they request it, be appointed counsel, whether they can afford it or not. So that was the first time, really, that the Supreme Court said that you're entitled to representation by counsel. It was about 20 years later in another case, Betts versus Brady, where the issue of counsel for anyone charged with a felony came before the Supreme Court. And actually the Supreme Court at that time said, no, you're not entitled to counsel if you're charged with a felony. They said absent illiteracy, and this is the Supreme Court opinion, absent illiteracy, stupidity, or a complex case, you're not entitled to counsel. And it wasn't until 1963 in the case of Gideon versus Wainwright, and I think I popped to, yeah. Yeah, I'm not sure where there's one slide missing, but in the case of Gideon versus Wainwright, which is, yeah, those three cases. Gideon versus Wainwright, a landmark case, a watershed case, really, in American criminal justice. This is the 50th anniversary of Gideon versus Wainwright. Decided in 1963. Clarence Gideon was a drifter, a petty thief who was arrested in the state of Florida, and he had asked for counsel. He came to the court with no money, no resources, and the judge told him almost apologetically that the law in Florida says that you're not entitled to counsel unless you're charged with the capital offense. And Clarence Gideon told the court, I think the Supreme Court said that I'm entitled to counsel. And he went to trial himself, was convicted, and ultimately his case made it to the Supreme Court. And ironically, at that point, the United States Supreme Court appointed him counsel for his Supreme Court appeal. And the counsel that they appointed to him was Abe Fortas, who became a Supreme Court justice himself. And I had a chance to listen to that argument, and you know, Abe Fortas was very learned lawyer at the time, and very deliberate. And if you listen to his argument, it's really interesting. And one point that he makes in the argument is that Clarence Darrow, who was probably one of the most famous criminal defense attorneys in the history of this country, he had been arrested. He got in some criminal trouble himself. And Abe Fortas said to the Supreme Court in his slow, deliberate fashion, he said, do you know what Clarence Darrow did? He hired a lawyer, is the way he said it. And he did. So it just gives you an example. Here's the best defense attorney in the country. He hires a lawyer when he gets arrested. And the interesting thing about Gideon versus Wainwright at the time was that it wasn't that shocking across the country that the Supreme Court said that everyone who's charged with a felony is entitled to counsel. And the reason being was, at the time, 37 states had either a statute on the book, a rule, or a court decision that said that indigent defendants were entitled to counsel. Another 8 states did it by practice. They just normally appointed a counsel for someone charged with a felony. So there are only 5 states, North Carolina, South Carolina, Florida, of course, Mississippi, and Alabama, that did not provide counsel for indigent defendants. So it wasn't really as earth-shattering a decision at the time. What was happening in the country was basically confirmed by the Supreme Court. Later, another 20 years later, the court in Strickland versus Washington said, not only are you entitled to counsel, you're entitled to the effective assistance of counsel. In that case, Strickland was charged with murder. He was convicted of first-degree murder, sentenced to death, and he suggested that his lawyer did not present mitigation evidence on his behalf during the penalty phase of his trial. And what that means is there were things in Strickland's background that he thought might convince a jury not to sentence him to death. And that's important, and is going to lead us in what we're going to talk about in a moment. Mitigation, presenting a profile of your client to the court that puts your client in the best possible position to succeed or to seek alternative sentencing and things such as that. Well, what the court basically said was that if a lawyer is deficient in the way that they present their case, or in this case mitigation, and that deficiency is prejudicial to the client in the outcome of the case, then they're entitled to a new trial. They set that standard in that case, but actually Strickland didn't benefit by it, because the court found, here's the standard for the future, but your client didn't fall below that standard. So Strickland was executed about 2 months after this decision that became a landmark decision in the courts. So that moves us to about 25 years later. I don't know why we're... Yeah, go back to those other 2 cases if we can. back to the other cases. These two decisions came down this year. And basically, what these decisions did was take Strickland a little further and take Powell and Gideon a little further. And what I mean by that is what Fry and Cooper said this year was that the Sixth Amendment does not only protect a defendant's right to a fair trial, it also protects a defendant's right in the pretrial proceedings, such as plea bargaining. So to give you some perspective, in the past, if you refused to plea bargain for your client, or you didn't even tell your client about a plea bargain that was offered, as long as you went to trial and had a fair trial, everything that happened before that, the court said didn't matter, because all the Sixth Amendment did was ensure that you had a fair trial. Cooper and Fry says that now the Sixth Amendment protects plea bargaining, and I think that's very important for lawyers. In these two cases, in Cooper's case, it was poor advice in the plea bargaining process. What happened in Cooper's case was he was a defendant, he shot a guy, and he shot him in the legs multiple times. And his attorney advised him, well, you know what? They can't really get you on attempted homicide because you didn't shoot him above the waist. I'm not sure where he got that, but it was completely wrong. His client relied on it. He went to trial and was convicted. In Fry, there was a plea offer made to the defendant. His attorney never even told him about it. He went to trial, got convicted, got a hefty sentence. So in those two cases, the court said that's ineffective assistance of counsel at the plea bargaining stage, and it's now protected by the Sixth Amendment. And I think those are extremely important decisions for lawyers who are practicing criminal law. And we'll try to get it. The last case I want to talk about is Miller versus Alabama, which is another case that was decided this year by the United States Supreme Court. And what the court decided in Miller versus Alabama was that life in prison, mandatory life in prison. They struck down mandatory life in prison for juveniles convicted of first-degree murder. So in Pennsylvania, for instance, if you were a juvenile charged as an adult, convicted of first-degree murder, you had a mandatory sentence of life in prison. In fact, Pennsylvania has more juveniles serving life in prison than any other state in the country. There are about 480 juveniles or people in state prison who committed first-degree murder as juveniles. The Supreme Court said you can't do that. You can't make it mandatory. You can still sentence a juvenile to life in prison, but it can't be mandatory. And what's important about that is that to deal with that decision, the Pennsylvania legislature passed a bill this summer which said that if you're 15 or older, you could get 35 years to life. If you're 14 or under, you can get 25 years to life. But what they also said was, specifically in the legislation, that there were things that the court must consider when making a decision on juvenile sentencing. So they must consider age-related characteristics like mental capacity, maturity, criminal sophistication, criminal history, institutional conduct, and any other relevant factors. So basically what the legislature did is they wrote in a requirement to consider mitigation. The judges must consider mitigation. And what that means is that lawyers must present that mitigation. So I see the future, especially in juveniles charged with first-degree murder, a lawyer will have the same responsibility that a lawyer has in a capital case. When an adult is charged with first-degree murder, you have that responsibility to present mitigation. If you don't do that, I think it'll be ineffective assistance of counsel. And there are other commentators who believe that. There's a professor, Beth Caldwell, who said in an article just this year that it's incompetent for counsel to fail to present this information to a judge charged with determining a young person's fate. So when we look at these cases in total and this progression over the last 80 years, your right to counsel in a capital case, your right to counsel, your right to effective counsel, your right to effective counsel at plea bargaining, and your responsibility by law in Pennsylvania to present mitigation on behalf of a juvenile really sets us up for what I think is something that every lawyer is going to need to do and to do more effectively, and that is to advocate at sentencing. I don't think that mitigation is really an issue just for death penalty cases. Fry and Cooper make that clear. The idea of sentence advocacy is really preparing a detailed profile on behalf of a client, someone with the skills, the background, education, and experience to provide credibility to those specific issues, and then advocate for an alternative sentence that promotes accountability, public safety, and system efficiency. And really, system efficiency is an important component of this. And when I talk about system efficiency, what I'm talking about is dollars and cents. Right now, in Pennsylvania, with the justice reinvestment in many states across the country, policymakers are looking for ways to decrease prison population, to find alternative sentences, to save on those costs, because obviously, as you may well know, the costs of incarceration have soared in this country, and a great deal of money in Pennsylvania and states across the country is spent on housing and warehousing inmates. And I think at this point, policymakers are looking for alternatives, and sentence advocacy is one way to do that. Why hire a sentence advocate? There are a couple of reasons. Number one, in Pennsylvania, as with the federal government, and the lawyers in here will be familiar with United States versus Booker and Blakely versus Washington, which said that the federal guidelines are not mandatory. The sentencing guidelines are not mandatory, that they're advisory. And actually, there's case law in Pennsylvania, Commonwealth versus Holliday, which says that the sentence guidelines have no binding effect. They create a presumption in sentencing. So you can advocate for your client at sentencing, even with the Pennsylvania sentencing guidelines. And there are a number of different situations where I think sentence advocacy is essential for your client. Number one, plea negotiations. How do you effectively negotiate a plea if you don't know the complete profile and background, all the mitigation, all the factors that are important for a judge to make a decision, if you don't know those at the very earliest stages of the case? So you can sit down with a prosecutor with a package and say, look, here's my client, here's his history, whether it's substance abuse, whether it's abuse as a child, whether it's mental health issues, whether it's other physical trauma that can contribute to his criminogenic ways. So there are a number of reasons why you'd want to have that at a plea negotiation. Certainly, if you have a client who's convicted at trial, you want to be able to present that kind of package to a trial judge who's going to make a decision on the punishment in a particular case. Cases where it's an open plea. Sometimes, strategically, a defendant pleads guilty openly, which means there's no real plea bargain. There's no specific time. There's no charges. You're going in front of the court, and you want to argue for a specific sentence. Sometimes there are situations where a prosecutor and a defense attorney both agree to a certain sentence, but they're concerned about whether the judge will accept the terms that they've negotiated. So a sentence advocate can come into court and make a presentation about why this is the best sentence for a defendant. There are cases, parole violations, parole violation hearings. When someone's violated their parole, those issues are left open And often you go into the court not knowing what your client's going to get. So you want to go into court prepared to argue for a specific sanction. But there are also other reasons to use sentence advocacy. Larry and I have worked together on a case that is actually going to be a parole violation that we're going to deal with very soon. Again, going into court, putting the best package together for that specific client. In the case that we're dealing with, employment is the issue. So we've done a great deal of research and presented scientific studies that show that employment training can have an impact on someone's recidivism rate. So that's the kind of work that can be useful. Number one, what you're going to do, and I've listed them here, is make recommendations for alternative sentencing. Larry is going to talk about some of the work in terms of risk assessment. Because as we said, a component of this is not only the financial aspect in some situations, but also public safety has to be a #1 priority, and explaining to the court why this particular defendant, if released early, if having a shorter sentence, if having a community sentence, would not be a threat to public safety. The most important thing is compiling information. Police reports, criminal history, court transcripts, information from bail hearings, from preliminary hearings, from pretrial proceedings, all these different areas that would have any pertinent information, is accumulating that information. Interviewing the defendant, interviewing people who know the defendant, having evaluations done. In my work on the parole board, we used many evidence-based tools to assess risk and assess other aspects of defendants. Just to give you an example of a couple that you may be familiar with, the Texas Christian University drug screening test. Every inmate who's considered for parole goes through this assessment, which gives you a numerical score about their drug and alcohol problems, and also is used for treatment. There's another risk assessment tool that we use. It's called the Level of Service Inventory. And it was originally created as a tool to determine what treatment plan an inmate should have in prison, but it's evolved into a risk assessment tool. Gives you a numerical score about this person's potential risk. Those are important factors that you'd want to put into a sentence advocacy packet that you would provide to a court. Really, it's about helping defendants help themselves in a lot of ways. A sentence advocate can structure a plan for the court that a person will participate in certain treatment, in certain counseling, provide written verification that they show up for work, that they're participating in any education program that they're required to participate in. So there's a number of things that you can do. It's almost like, in some situations, an alternative to what the court is going to hear from adult probation. It's not necessarily a confrontation with adult probation or an alternative to a pre-sentence report. In fact, in a lot of situations, if you do this work early enough, you can present all this information to adult probation and actually ask that they include it in the pre-sentence report that's provided to the judge. And in fact, if they don't, under Rule 703 in Pennsylvania, you can object to the court that you've provided information to adult probation that they haven't included in their report. So there's a lot of important things that you can do for your client to increase their chances of being successful at sentencing. We'll see. Testifying as an expert. Can a sentence advocate come into court and testify as an expert. There are a couple of cases in Pennsylvania that are important. Miller versus Brass Rail Tavern, which is in the written materials, basically says that if someone has a reasonable pretension of specialized knowledge, in this case, Larry Ferletta, a DEA agent who's conducted thousands of interviews, can come into a courtroom and talk about interviews that he's conducted on behalf of a client. My background, for instance, as a prosecutor and a parole board member, provides me with specialized knowledge in these particular instances. And obviously, in Pennsylvania, it's still the Fry test in terms of expert witness and expert materials generally accepted in the scientific community. But also, even for sentencing purposes, even if you're not qualified as an expert, you can come into a sentence and testify as to hearsay, essentially, but what you've learned about this defendant, what you know about this defendant, what you think would be best for this defendant. And the Supreme Court in Green versus Georgia said that is certainly appropriate. But I believe that that testifying and preparing a report at the earliest stages of a case is the most beneficial thing that you can do for your client. But not only that, I think in some cases, and I think this is going to evolve over time, in some cases it's going to fall below the standard of effective assistance of counsel if you don't do this. This is what the future is for lawyers in terms of advocacy on behalf of their client. Certainly, being a great trial lawyer is important in the negotiation process, because you can say, I'll go to trial and win this case. But the failure to negotiate, the failure to be involved in that process and be prepared for it, I think will have dire consequences for your client and possibly consequences for your own practice. With that, I'm going to turn it over to Larry to talk about risk assessment and other aspects of sentence advocacy.
Good morning. Thanks, Matt. I actually have a dual role here today. One of them being on the staff with Attorney Paper. About 6 years ago, after I retired, Angelo and I had been talking about putting something together from a law enforcement perspective, along with using medical treatments and so on. And I think we all began to realize over 30 years in law enforcement that we just can't put everybody in prison. It's designed, in my view, for the most violent criminals there is today. And on a federal level, we have a different perspective because we deal with some of the most violent criminals that the world has to offer. One of the things that that Matt and I had gotten together and talked about risk management and how it could effectively be applied to the criminal justice system. Matt and I basically go back a long way from the first day he was elected as a new district attorney. One of the unspeakable crimes happens when you assault an institution of this country, just as what happened to the kids that have been killed in Connecticut. One of the institutions that were assaulted in Newcastle and Lawrence County was the Lawrence County Courthouse. A couple defendants in the case decided that they wanted to firebomb the courthouse. And so what they did was they threw a Molotov cocktail, scorched the side of the courthouse, thinking that if it penetrated the window, that it would burn down the courthouse. Well, obviously that didn't work. But being as a new district attorney, Matt, I'm sure, was under a lot of pressure by the judges to solve this issue. And fortunately, we were enough during the course of our investigation at the time to come up with the actual person who threw the firebomb, who was also a defendant in a federal drug case. And we were able to gain evidence on this individual, which I presented to Matt, and I know he was happy that day. So let's get right into risk management. Risk management plus advocacy equals freedom. And I'll give you a definition of risk management. It's the identification, assessment, and prioritization of risk, whether it's positive or negative, followed by coordinated and economical application of resources to minimize, monitor, and control the probability and or impact of unfortunate events and to maximize the realization of opportunities. For the lawyers that are here, if this sounds familiar to you, it's an argument for bond, for bail, for probation, for minimum sentencing, and supervised release. Now, what are some of the methods that we would use? Well, we identify the threats. What are those threats? Is there a criminal history? And some people have extensive criminal history. But one of the most important elements is there a propensity for them to commit violence. You have to assess the vulnerability of the client's substance abuse issues, which is why Signature Hill and myself and others became involved in the issues at first. We have a complex risk assessment, and the one thing that that individuals who are criminal defendants, the first consequence that they have to be able to willing to accept the consequences for their behavior. And you have to determine the risk, the likelihood and consequences of specific attacks. For example, was it a domestic case or a witness? Was the witness did the client at the time or defendant make threats to the victim or any witnesses? Now, we want to identify ways to reduce risk. And how do we do that? Close supervision, not only by probation, but also by family members, because those people have to take some responsibility in this issue as well. Psychological counseling, treatment, mentors, very important. Clergy, another important matter. Employers, and of course, educators, attorneys' offices, and etc. Now, once we had put this thing together, we know that attorneys' times are very limited. And so you need the professionals behind this to help you with your case. Now, what we're doing is we're prioritizing the risk reduction. And it's based really on a strategy, a plan outlined to the court, and the reasons why that client should be released. And I can tell you, in federal court, and I'll get to that in a minute, if your client has a violent criminal past, he's not getting out, period. But on the state level, I see a lot different issues, and of course, white-collar crime in federal court. But one of the most important things is employment and education. You have to be able to tell the courts that there is somebody that's going to take this individual as soon as he is released from the custody of the authorities. Now, we also look at whether this individual had a substance abuse problem, and of course our military veterans who are now returning back from the war that have all these other issues, post-traumatic stress. And even post-traumatic stress happens in a lot of different things. Law enforcement also suffers from post-traumatic stress because of the things that you begin to see. What are the principles of risk management? You have to be able to convince the court that you're creating value. For the client, why should it be released or placed on bond? Does a client have a potential future to enhance his or her life? Can education provide a bright future? Technical schools, trade schools. And what Matt was talking about, our first real test case is coming up here very shortly. And so we're making an argument to the court that this individual, even though he's had a substantial past including robberies, that there is a small window of opportunity for them to get back out and start a job. When I went to Catholic schools, the nuns told us, idle minds create problems, and it's come true. What are the potential risk treatments? Are there any trade-offs? GPS, close supervision, and believe it or not, the client in this particular case, even when he was released from state parole, there was really no control with him other than reporting to his parole officer. How do they get themselves in trouble? Because really there is a lack of supervision. There's not enough parole agents in the state of Pennsylvania to supervise an inmate that's been released. I know parole agents personally, and they have 20 or 30 or maybe 40 clients that they have to monitor. It's impossible. You're not going to prevent somebody from going out to commit crime. Let's talk about risk reduction. Finding a balance between being positive or negative and a benefit of your effort. Will the defendant be released, or is the defendant going to be incarcerated until the time of trial? One of the important things is risk sharing. I think this is probably one of the highlights as to where you may be able to get a defendant released. But remember, are the courts willing to share the risk? Are family members, employers, and others willing to share the risk associated with this particular defendant? Because judges do not like to get egg on their face once they release a defendant who goes back out and violates probation or parole and commits another crime. There's nothing to go back in the court as a defense attorney and get the ire of the judge. And we create a risk management plan. There must be a plan in place to convince the courts and the prosecutors, probation, and others to release a defendant on bond. Now, I was involved in a case where a high school student from Mount Lebanon was charged with 4 counts of rape. I worked on his case and did the investigation for the attorney at the time. This kid came from a well-to-do family, upper middle class, never been in trouble in his life. And what happened in that particular case, he went to the Schumann Center for at least 2 weeks. And for those that are from Allegheny County, the Schumann Center is not a nice place for kids to visit, especially kids who've never been in trouble. Because the kids that are in the Schumann Center are kids who have a history of violence and being in trouble. So you can imagine that this kid was in shock. We were able to get him out under house arrest with a GPS device. Now the problem was he had to stay home. He was not allowed to go outside. One of his parents were retired. So now the parent is a prisoner in this issue because this kid could not even open the front door, stick his leg up. So what happened was I approached the lawyer in the case and said, look, I think I can get him out. I think we can convince the court. And here's the reason why. First of all, he's never been in trouble before. What threat does he pose to these other kids, the victims? So I testified in juvenile court, and I am an expert witness in federal court and some state courts. And we got him out. Now his dad was at least be able to let this kid outside and go about his daily business. And by the way, I interviewed all the witnesses involved in the case. The rape charges were dropped. The kid went back to school. Limitations. Know the distinction between risk and, of course, uncertainty. Will the courts release defendant if there's an uncertainty or the likelihood that defendant participating in additional crimes or fleeing the jurisdiction. You have to convince that court that you have a plan in place. Don't go to a court, as most of you know, unprepared. And I think that this will add to your credibility to the court if you present some kind of plan to the judge. And the other thing that I mentioned, even though that you're an advocate for the defendant in the case, there's another part of this that you have to be able to convince, and that is the prosecutor's office. And in some cases, with Matt and I's background from a law enforcement perspective, and going in and talking to the DA's office with a lot of credibility. I know it works because I've done this in the past. Now, if some of you practice in federal court, there's a two-pronged test on the release of the defendants. One of them, again, is a danger to the community, and the other one is a flight risk. In my 20-some years with DEA and taking federal prosecutions, anytime the government has asked for detention, it has been granted by the court. And why? Because the individual that we arrested has a criminal history. And we can argue that he is a danger to the community. And of course, most drug traffickers have large amounts of cash, resources, so they can flee the area, the country. It's not like some street drug dealer who gets picked up in Farrell who has those kind of resources. The other thing that we had talked about was a conspiracy. I'm a recognized expert in conspiracy law in U.S. District Court, and I've never lost a case. And the reason why I never lost a case is because collectively, working with the prosecutor as a team, we were able to go out and be able to put everything together. Drug cases, especially on that level, people think that you have to bring in a ton of cocaine and show it in front of the jury. No, you just have to be able to prove that they moved a ton of cocaine. So what would be our strategy for release? Transferring risk to another party, the bail bondsman, family, community, pretrial probation. Now, as Matt was saying, part of the element here to sentencing advocacy is the investigation part of it. Thorough interviews, a detailed background report. What is a thorough interview? I've been around lawyers for over 30 years, and to be honest with you, I don't think they do a thorough job doing interviews of their clients. And that's not to criticize them, because it's a matter of time and having other clients. In my expertise, I've been able to interview people, get more information from them, and then turn it back to the lawyer and say, look, here's what you potentially might have missed. And yes, they do miss things. And so it's good to work as a team concept. And I tell lawyers, when you have a defendant or a client, let me interview them, because I can go from the moment that they were incarcerated, from everything, from the time that they woke up, went to sleep, got back up, and at the end of the day, what they did. And it's not to get them to confess, it's to have an accurate picture of what they did. Part of that interview process is then you identify the risk associated with this particular defendant. And I believe it assists with mitigation. Government risk management. The government has been utilizing risk management for a considerable amount of time. What are they? Well, I think most lawyers have seen a pre-sentence report, the PSI as it's called, And you have to look at this as taking a different approach. Should you wait until the government gives you a report about your client? Of course it's the easy way out. But there may be things in there that the PSI does not give you the full picture of that defendant. And let's face it, they're not going to tell the probation officer every single thing. And if you believe that that defendant is honest with that probation officer, then you better start thinking about that, because I know they're not. They minimize their information only to protect themselves. One of my other expertise is dealing with confidential informants. Over the past 30 years, I've had some issues with informants, and I can tell you I don't trust them. And anybody in law enforcement that trusts a confidential informant better get their head examined. I've been set up by informants. In one particular case, I was doing an undercover drug buy, and the informant came over and met me in a shopping center. And we were talking about, I was working undercover on a motorcycle gang, pagan motorcycle gang. The informant gets me out of the car and we're talking. And a couple individuals came by, drove slow, and this is back in the 80s, so we didn't have the high-tech cameras that there are today, even with phones. But if you all can recall the bar, that strip of flash bar that would be on top of a camera. So this car drives slow, and they try to take my picture. Well, the bar falls over. And it kind of stunned me for a minute. I'm thinking, well, what's going on here? What's happening? So I looked at the informant. Now the informant goes, well, I don't know who that was, but why don't you come up and meet me at this other location? And I have some street sense about me. I sort of learned that as a young child, where I grew up on the south side of Newcastle. So that helped me a little bit too. And no, I told the informant, I said, I'm not meeting you at this location. You meet me at this location, because the location that he wanted me to meet him at was a remote location. I went to a local 7-Eleven waiting for him, and of course, he never showed up. We eventually got him back and arrested him, and of course, he confessed that they were going to do some bodily harm to me. So that's why I don't trust informants. And that's why in court, even though the jury looks at them in a certain way, all the jury trials that I've been involved with, most of the jurors have told me that they really didn't trust that guy and his credibility was at issue. And the only reason why the jury convicts people is because the independent cooperation that the agent or law enforcement officer does. If they don't independently corroborate that informant, they have no case. As I said, you can't trust them. Witness protection program. This is another thing that I did in my career, putting people into the witness protection program. And let's face it, they're criminals, because it takes one criminal to catch the next. Mother Teresa is not involved in this issue. There's no way that the government can catch anybody without the informant. One of the things that I looked at in the past years of doing these cases in witness protection, because there are a series of things that have to be done when you put people in witness protection. It's not like TV. You put them in and they go on their way. There's a complete risk assessment done on them, complete psychological evaluations, just a compile of things to get them set up. Now, when you take a look at this case, because this is what really brought my attention, because I talked to some federal prosecutors about this. And this individual, his name is Sammy Gravano, the Bull, as they called him on the streets of New York. He was a hitman, part of the John Gotti organized crime in New York. Now, on the witness stand, because he testified to the government, for the government, he admitted to committing 20 homicides, 20 of them. And I began to scratch my head and said, well, what credibility does this guy really have? Well, the government obviously had to independently corroborate somebody like Gravano. Gravano gets put into the witness protection program, and it wasn't probably about a year or two later, maybe a year later, he's released from prison. Now, this is a guy who committed 20 murders, released from prison. What's he do? He goes back into selling drugs. And of course, DEA in Phoenix arrested him, and he's now back in jail for where he should have been in the first place. Recommended plan of action. One of the things that the courts look at is the acceptance of responsibility. And Matt can tell you that on parole hearings, if this individual now starts to make excuses for himself, the parole hearing is going to deny this individual from being released. The client that we're working on, of course, and you look at them, and I tell these individuals, listen, I've been around a long time. Don't waste your time lying to me. If you do, then I'm going to walk out this door. Total absence from substance abuse, criminal associates, and if the client is willing to accept directions. Now, you look at this and you say, well, wait a second, isn't this what probation does? Oh, yeah. But these are those strings attached for releasing that client. And if he screws up, he goes back to jail. And this is why it's important to have somebody oversee or at least be in contact with this individual on a regular basis. One of the things that I did with this particular client is that he agreed upon self-imposed restrictions. Now, when he was released the first time, he had none of these. What I recommended is that it would include curfews. Now, here we are having a 24-year-old man telling him that he has to be in the house at 10 o'clock at night, Monday through Friday, and 11 o'clock home on the weekends. That is one of the aspects, in my view, is convincing the court that this is part of the total responsibility that this defendant is accepting. Employment, education, treatment, housing, work release, counseling, GPS, mentors, relationships with family. I think family plays a key role here, but unfortunately there are some defendants that don't have that family structure. In our particular case now, we do. Part of the self-imposed restrictions, Matt and I worked together on looking at some forms for accountability for this individual. We looked at the key things upon release: employment, education, and what we came up with was to give him an attendance record. It's like going back to school and making sure that the child's gone to school every day. So, and counseling. So what this client is going to do is that what we're going to propose to court is that the day that he gets released, he starts a job. I have already lined up an employer through the family. I interviewed the employer. He goes back to college or technical school. I interviewed, or we got a letter from the technical school. I talked to the counselor again, and through all of this, we put this package together, convincing the court that this is what this young man is going to do. The two important factors, as I mentioned to you, is employment and education. So, what we have here is we have, upon his release, we have a job for him, and he's going back to school. The school will accept him back, even though that they know that the guy's sitting in jail right now. The counselor who has counseled this kid in the past as a juvenile will start immediate counseling. So when this individual goes to the counselor, the educator, and work, he's going to bring an attendance sheet. And he's going to have that individual initial off that he was there. And why do we do that? Because it's accountability. And if you submit that to the probation officer, he's going to know that this person is serious about his release. And it will establish your credibility not only with the courts, but with the probation officer themselves. And not that we're trying to do their job, but it's to enhance their job. Like I said, they can't monitor these guys. So we have a good argument that we have done a self-imposed restrictions for this defendant. And we'll see if the judge buys it next week. A comprehensive investigation plus risk management and advocacy will create recommendations. And as Matt mentioned, and Angelo has mentioned, there are millions of dollars being spent on people being incarcerated. And should the community continue to bear the cost of individuals who don't possess those inherent dangers to the community and to the victims of crime? And the last thing is, why hire us? Okay, I'll move to the next slide. Here's the resources involved in the case and how to get in touch with us. Now, the other thing that we talked about is the part of the risk assessment that we put together in this program. And you can see there's some things that close assemble each other. So what we're trying to do collectively is we have put a risk assessment on the drug end of this, using my expertise in dealing with the courts. And another case that comes to mind is a nurse who was a defendant in a case and was subsequently released because of some of the issues that we were bringing to attention of the court. If anybody has any questions, please ask us.